Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. I am going to go over the motion that I have been waiting to be filed. Granted, I don't think it's going to be a real problem that the media and the public is going to get thrown out of the pretrial proceedings in the Stephen Stern trial and case, but I knew that the media attorneys would be filing this any day now. And they filed it, it looks like on Monday afternoon. It did hit the docket today, obviously the opposition to this order. And it's 13 pages long, so I am going to go through it. And again, I am not an attorney, and I do not play one on the YouTube streets. So again, you can see the filing up here. It looks like it was filed at 3:36 p.m. Monday, March 10th. And it does take some time for documents to hit. So we went through as of today, which would be March 11th, which was Tuesday. That's when I saw it today, when I was looking up to see what's starting to happen. Again, this is in the circuit court for the 9th Judicial Circuit in and for Osceola County, Florida. Obviously, the state of Florida versus Stephen Stearns. This is the media interveners' opposition to defendant's motion for closure of all pretrial proceedings. As you can see, it's covering the major media that's local here to Orlando, Central Florida. So it's pretty blanket as far as that's concerned. Non-parties and interveners, WFTV, WKMG, Fox 35 Orlando, Wesh TV, and the Orlando Sentinel, collectively the media interveners, respectfully move to intervene in this case for the limited purpose of opposing defendant's motion for closure of all pretrial proceedings filed on February 18th, 2025. And these, in the parentheses, that's what they're going to refer to it going forward. If those, we've gone through a few of these here, but just for anyone who doesn't understand that. So they will continue to refer to this as the motion, and then media interveners will be referred to as all the news media. Background. In March of 2024, the state of Florida charged Stephen Stearns, defendant, with 60 criminal counts, including sexual battery of a child under 12, lewd or lascivious molestation, and unlawful possession of materials depicting sexual performance by a child, sparking significant public interest. In a misguided response to the heightened public interest in the case, defendant now asks the court to enter an order closing all pretrial proceedings in this cause to the press and public. Motion at 1. To justify the expansive remedy he seeks, defendant alleges that unless the court operates in complete secrecy from now until the trial, he will forfeit his right to a fair trial. Motion at 1-3. The media interveners are news organizations that have reported and continue to report on the instant matter. Each relies as part of its news gathering processes on multiple sources, including judicial records and proceedings. The media interveners have standing to challenge defendant's attempt to close judicial proceedings. See Barron versus Florida, Freedom Newspapers, Inc., 531 Southern 2D 113 118 Florida 1988, Morris Publishing Group LLC versus State 136 Southern 3D 170 775 Florida 1st DCA 2014. Argument. More than 75 years ago, the United States Supreme Court recognized that what transpires in the courtroom is public property. Craig versus Harney, 331 U.S. 367, 374, 1947. And in the decades since, Florida has steadfastly ensured openness and transparency among all three branches of government. See Forsberg versus House Authorities of City of Miami Beach, 455, Southern 2D 373, 378, Florida 1984. Florida has been in the forefront of promoting open government. Overton J. concurring. League of Women Voters of Florida versus Florida House of Representatives, 132 Southern 3D, 135, 144, Florida 2013, noting the strong public policy as codified in our state constitution favoring transparency and public access. State versus Wooten, 260 Southern 3D, 1060, 1072, Florida 4th DCA 2018, noting in the context of judicial openness, Florida's posture that the default should be for transparency and disclosure. See also Article 1, Section 24 of the Florida Constitution and Florida Rule of Judicial Administration 2.420, building atop the First Amendment to the United States Constitution and Florida's common law provisions by enhancing Floridians' rights to access government and judicial matters. Florida courts have cited many reasons for the state's staunch posture of judicial transparency. For starters, the Florida Supreme Court explained that openness is basic to our form of government, and public trials are essential to the judicial system's credibility in a free society. Barron 3531, Southern 2D at 116, Florida 1988. Yet the right to open courts not only ensures that the public is kept fully informed of judicial proceedings, but it also serves the additional role of providing essential protections for litigants. As the Florida Supreme Court has emphasized, transparency is essential to testimonial trustworthiness because it produces in the witness's mind a disinclination to falsify by stimulating an instinctive responsibility to public opinion and inducing fear of exposure of falsehoods. ID at 117, citation looks like it was omitted. An Angelenos effect is produced upon counsel and, just as importantly, the court. In acting under the public gaze, they are more strongly moved to a strict conscientiousness in the performance of duty. ID and citation has been omitted there. See also Wooten 260 Southern 3D at 1072, explaining that public access to judicial proceedings is important to the public's understanding of the function and operation of the judicial process and the criminal justice system, and may operate as a curb on prosecutorial or judicial misconduct. Citation omitted. As the Florida Supreme Court summarized, public access to the courts is an important part of the criminal justice system, as it promotes free discussion of governmental affairs by imparting a more complete understanding to the public of the judicial system. Such access gives the assurance that the proceedings were conducted fairly to all concerned. Aside from any beneficial consequences which flow from having open courts, the people have a right to know what occurs in the courts. The Supreme Court of the United States has noted repeatedly that a trial is a public event. What transpires in the courtroom is public property. Public access also serves as a check on corrupt practices by exposing the judicial process to public scrutiny and protects the rights of the accused to a fair trial. Finally, because participating lawyers, witnesses, and judges know their conduct will be subject to public scrutiny, it is fair to conclude that they will be more conscientious in the performance of their roles. This entire paragraph is definitely a favorite of mine, and the first thing I think of, and we don't like to cross cases, I know, but the whole Delphi situation, it was not clear because of the access situation to the media, besides they were in the courtroom taking notes. So that to me makes a big, big difference in these cases. Miami Herald Pub looks like Co. versus Lewis 426 Southern 2D 1 6 through 7 Florida 1982, citations omitted. Thus, as explained time and again by Florida courts, open and transparent judicial proceedings increase public confidence in the judicial process, enhance the credibility, legitimacy, and integrity of the courts, and protect the rights of all entities involved by actively opposing biases, false or inconsistent testimony, due process violations, improper prosecutorial conduct, and errant legal action. Based on these public policy considerations, when a trial court is faced with a request to close a courtroom, it should begin its consideration with the assumption that a pretrial hearing be conducted in open court unless those seeking closure carry their burden to demonstrate a strict and inescapable necessity for closure. ID at 8, emphasis added. To that end, this court must apply the three-part test established by the Florida Supreme Court in Miami Herald on Publishing Co. versus Lewis. A. Closure of a proceeding necessary to prevent a serious and imminent threat to the administration of justice. B. No alternatives other than a change of venue would protect the defendant's rights to a fair trial. And C. Closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. ID at 6. The moving party must satisfy each of these elements by a preponderance of evidence. Mere allegations will not suffice. CID at 8. Those seeking closure have the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary, the presumption being that a pretrial hearing should be an open one. Yet, as shown below, defendant has failed to produce sufficient evidence to satisfy any of the three elements, much less all of them. A. Defendant has not established that closure is necessary to prevent a serious and imminent threat to his fair trial rights. Beyond defendant's repeated insistence that his rights are threatened, the only facts the defense presents to justify his request for closure are that A. Potentially inadmissible evidence may arise pursuant to defendant's anticipated pretrial motions, and B. This case has attracted and will continue to attract significant media attention. Motion at 1-2. Neither of these facts, however, justifies a finding that closure is necessary to prevent a serious and imminent threat to defendant's fair trial rights. 1. The potential inadmissibility of evidence does not require closure of pretrial proceedings. Defendant asserts that he plans to file multiple pretrial motions to suppress and exclude evidence. See motion at 2. In some instances, he states, this will involve evidence which may later be found to be inadmissible. Included in these discussions of Mr. Stern's evidence will be Mr. Stern's statements to the police, the medical examiner's findings, and potentially discussions on evidence related to statements from minor children. Florida law is clear, however, that admissibility of evidence is not prohibitive of whether such evidence is accessible to the public. See State v. Lugo, 35 Media L. Rep. 1348 Florida, 13th Judicial Circuit, September 19th, 2006. The need to examine evidence for its admissibility is not one of the prongs set forth in Lewis and is not sufficient to justify closure. State v. Houston, number 13, CF-014443, Florida 13th Judicial Circuit, July 17, 2014. The admissibility of evidence has no bearing on whether evidence is or is not public record. State v. Notchman, 44 Media L. Rep. 1608, Florida 13th Judicial Circuit, March 23, 2016, performing a Lewis analysis and rendering inadmissible evidence available to the public. For example, in State v. Kozma, the court suppressed a defendant's statement that included potentially damaging admissions. 1994 WL 397438, Florida 17th Judicial Circuit, February 4th, 1994. The court, however, refused to seal the statement, stressing that even where pretrial publicity includes publication of inadmissible evidence or confessions, a defendant can still receive a fair trial. In fact, the Lewis test itself arose in the context of a suppression hearing for the confession of a 14-year-old murder suspect. See Lewis 426 Southern 2D at 27, explaining that a carefully controlled suppression hearing can itself be conducted in open court without creating any prejudice because the issues concern not so much the contents of a confession, but the circumstances under which the prosecution obtained this material. The Florida Supreme Court determined that suppression hearings are of great moment beyond their importance to the outcome of prosecution. Lewis 426 Southern 2D at 8. A motion to suppress involves allegations of misconduct by police in prosecution that raise constitutional issues. Such allegations, although they may prove to be unfounded, are of importance to the public as well as to the defendants. The searches and interrogations that such hearings evaluate do not take place in public. The suppression hearing is the only opportunity that the public has to learn about the police and prosecutorial conduct. It is important that a decision of the trial judge on a motion to suppress be made on the basis of evidence and argument offered in open court, so that all who care to see or read the case may evaluate for themselves the propriety of the exclusion. That is why Florida courts regularly reject requests to close suppression hearings. See State example Pensacola News Journal versus Fleet 388 Southern 2D 1106, 1107, Florida 1st DCA 1980, State versus Sharrow 29, Meade L. Raptor 2503, Florida 17th Circuit 2001, State versus Living Good 12 Media L. Rep 1376, Florida 17th Judicial Circuit November 4th, 1985. Thus, defendant's position that pretrial proceedings featuring potentially inadmissible evidence should be closed fails purely as a matter of law. In addition, the defense has presented no facts to explain how, in the context of this case, any of the potential matters for consideration he enumerates in his motion would practically jeopardize defendant's fair trial rights. See State versus Montes, which is denying a defendant's closure motion under Lewis in part because the defendant failed to show how the public's knowledge of potentially inadmissible evidence would threaten his fair trial rights. 2. Pretrial publicity is not a sufficient basis for closure of court proceedings. Defendant argues that he cannot receive a fair trial in Osceola County because the instant case has attracted significant media attention. See motion at 2-3. This argument fails because defendant has not and cannot show that the jury pool is tainted or that the media attention has otherwise prejudiced his fair trial rights. First, defendant's argument poses this specious assumption that the entire prospective jury pool within a county of more than 400,000 residents is vulnerable to irreparable tainting. But with so many prospective jurors in Osceola County, the statistical odds for an impartial veneer are highly favorable. See Skilling versus United States. Given this large, diverse pool of potential jurors, the suggestion that 12 impartial individuals could not be impaneled is hard to sustain. As another court explained, impaneling a jury in a county with hundreds of thousands of residents essentially precludes the type of showing required by strict three-part Lewis test. See Kuzma 1994, noting further that a significant number of the public does not retain what is disseminated by the media or simply does not read newspapers or watch television. As a result, the feared impact on the fair trial rights of criminal defendants often does not occur, even in matters that have received extensive media coverage. Second, even if all potential jurors in Osceola County remembered what they read, heard, or saw in any media about this case, closure would remain unwarranted because publicity, which is all defendant has alleged here, is not synonymous with prejudice. as the Supreme Court explained. Prominence does not necessarily produce prejudice, and juror impartiality, we have reiterated, does not require ignorance. Jurors are not required to be totally ignorant of the facts and issues involved. Scarcely any of those best qualified to serve as jurors will not have formed some impression or opinion as to the merits of the case. Every case of public interest is almost as a matter of necessity brought to the attention of all the intelligent people in the vicinity, and scarcely anyone can be found amongst those best fitted for jurors who has not read or heard of it, and who has not had some impression or some opinion in respect to its merits. A presumption of prejudice, our decisions indicate, attends only the extreme case. This is definitely the truth as far as I'm concerned. A lot of people, even though this is a huge case in Osceola County and even Orange County and even beyond, a lot of people in the county don't know much about it. That's just the truth. Skilling 561, see also Murphy versus Florida. Qualified jurors need not, however, be totally ignorant of the facts and issues involved. To hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut the presumption of prospective jurors' impartiality would be to establish an impossible standard. Nebraska Press Association versus Stewart. Pretrial publicity, even pervasive adverse publicity, does not equitably lead to an unfair trial. State versus Hariff. Media L Rep 1415. Denying under Lewis is a defendant's closure motion, and noting that the mere existence of a preconceived notion as to guilt or innocence is insufficient to rebut presumption of a prospective juror's impartiality. To be sure, pretrial publicity in topical criminal cases is normal and expected. Rolling versus State, and media attention alone has never been a sufficient basis to justify closure of court proceedings. See Kozma 1994, noting that even massive pretrial publicity about a case is not enough to show a serious and imminent threat to the administration of justice or to the denial of fair trial rights. State versus McTeer, finding the argument that members of the public will lack impartiality due to the existence of adverse reports in the news is not compelling. Because defendant cannot illustrate the threshold Lewis element, that of serious and imminent threat to his fair trial rights, the court should deny the motion. B. Defendant has not established that alternatives to closure are insufficient to protect his fair trial rights. The second element of the Lewis test requires that the movement to show by a preponderance of the evidence that no alternatives are available other than change of venue, which would protect a defendant's right to a fair trial. Lewis 426 Southern 2D at 6. As explained above, defendant has not explained how his right to a fair trial is or could be jeopardized, but to the extent that his rights are implicated, he cannot demonstrate why an alternative short of the drastic measure he proposes would not suffice. Here, defendant has presented the court with no facts to suggest that an alternative to closure would not cure any alleged ills. For example, Lewis suggests voir dire as an alternative to closure, and defendant has stated no facts to suggest why the process of voir dire could not be used here to screen out potential jurors who cannot set aside any bias related to their exposure to reporting about this case. See also Murphy, explaining how voir dire can screen for possible animus. Lewis also states that preemptory challenges are an alternative to closure, and defendant has not explained why preemptory challenges could not be used here to strike any potential juror who displays or suggests partiality during voir dire. And yes, I know I'm saying that word incorrectly. I'm feeling a little tongue-tied, guys, so give me a little grace on that, hopefully. See Lewis Moreover, Lewis also lists admonition of the jury as yet another alternative to closure. And there is no reason why, if impaneled jurors indicated familiarity with prior reporting of the proceedings, the jurors would ignore an admonition by the court that their verdict can be based only on the evidence presented during the trial. See also Nebraska Press Association outlining alternatives to closure. C. Defendant has not established the efficiency and narrow tailoring of the requested closure. Here, defendant requests the indiscriminate closure of all pretrial proceedings. Yet the third prong of Lewis requires the movement to prove that closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. Lewis, 426 Southern 2D at 6. The Lewis court explained that when prejudicial information already has been made public, there would be little justification for closing a pretrial hearing in order to prevent only the disclosure of details which have already been publicized. Here, as defendant recognizes, significant details about the matter are already publicly disseminated. We all know that. See motion at 1, noting the extensive coverage by the press of this case. So defendant must show that potential public knowledge about hereunto unknown information will deprive him of his right to a fair trial, a burden he has not even attempted to bear. State versus Bush. There is no doubt that in this particular case, the information has already been well publicized. Accordingly, this court finds that defendant cannot meet her burden under Lewis. State versus Smith. As to the third prong of the Lewis test, the defendant failed to show that granting his motion would be effective in protecting against the perceived harm. Since much of this information has already been made public, there is little justification for granting the motion. State versus Parks. The defense has failed to establish that keeping the identified material sealed would be effective in preserving his right to a fair trial. The print media has already placed much of this material before the public prior to the filing of the defendant's motion. Sharrow, this case has already received publicity. Closure at this point will have little, if any, effect on any potential jury pool. Rather than a hindrance to a fair trial rights, heightened public attention only increases the need for the appearance of fairness, so essential to public confidence in the system. Press Enter Company versus Superior Court of California. To be sure, publicity is vital to an open and accountable judicial system, as former Supreme Court Chief Justice Berger explained. Without publicity, all other checks are insufficient. In comparison of publicity, all other checks are of small account. That is why any closure must be narrowly tailored to protect defendant's fair trial rights. Yet here, defendant seeks closure of all pretrial proceedings, regardless of the issues presented or even knowing what might be disclosed in them. Thus, in sum, because this matter has already received significant publicity and because nothing could be less narrowly tailored than the unqualified closure of all pretrial proceedings, defendant also fails to satisfy the third Lewis prong. And because defendant could not satisfy a single element of the Lewis test, the court should deny defendant's motion in its entirety. Conclusion. Before entertaining the draconian remedy of closing a public courtroom, Florida law demands an evidentiary showing that a defendant's rights are seriously and imminently threatened and that nothing short of a narrowly tailored closure will protect these rights. As shown above, defendant has failed to satisfy any of the three required elements to justify closure, much less all three. For these reasons, the media interveners respectfully request that the court deny defendant's closure motion. And as you can see, it's signed by their legal team there, Shulman Fugate P. LLC. And they're out of Tampa. It looks like they're the attorneys for the media interveners. So again, this is why we have these lawyers. As you can see, even reading some of their stuff can get you tongue-tied. But that's why they go to school for years and years, and they get paid the big bucks. More. So we think. The bottom line is, this is obviously a great motion, and I think the judge is going to, he's going to deny closing the courtroom. There's no reason to. Stearns' attorney, obviously, she's doing her job. Let's put it that way. Again, I can't understand how a female could take on this type of client, but also, again, everyone deserves competent legal representation and a fair trial. So, and that's not going to be a problem, because obviously we can see from these 60 plus motions that they have filed just recently, this attorney for Stearns, she's business, okay? She's obviously doing her job. She's, protecting her client as much as possible, and that's what he should get. I mean, regardless of whether we like him or not, and he's going to get his fair trial. As they stated, I didn't know the exact number in Osceola County. I'm glad that they put that in there. 400,000 people in Osceola County residents, and that could be low, but you can't tell me. I agree. You can't tell me that all these people paid that much attention to this case. Now, we all followed Maddie mostly from the beginning, or we're close to. And we also follow true crime. So we're kind of an exception to that. Not everybody follows these cases from start to finish. And I mean, I'm talking about from the moment they hear that Maddie Soto is missing, didn't show up to school, and then they find out that she's found deceased in St. Cloud, and that her mother's boyfriend is arrested for CSAM, and now he's being charged with her murder. Most people are not following this, and they may or may not even read that there's a trial coming or started. So most of these people, they don't follow these cases that closely, and they can be impartial because they don't know all these details that we know. They're not hearing all these interviews with the law enforcement and Stephen Stearns, Jen Soto, the school. They're not hearing all this stuff. They're not seeing all these photos. They're not reading all the documents, the discovery, and they're probably barely even reading the newspaper or watching the 5 o'clock news. So he is definitely going to be able to get, in my opinion, a fair trial in Osceola County. And if not, they could pull from Orange County. I've always said that from the get-go. And I don't think that's going to make a difference either. But again, even though I don't think that this motion that the defense has thrown out there is going to stand a chance, we have to wait to see what the judge says. But I think we're in pretty good hands as far as that's concerned. And again, the hearing for this whole motion is March 20th. I will not be able to make that one, and I'm probably not going to make the pretrial, but I am ready to go for May. But we will definitely be paying very close attention to this trial, to this pretrial, pre-pretrial, this motions hearing on March 20th, and I will keep you guys apprised of that. But as always, let me know your thoughts in the comments. And with that said, I hope you have a great rest of the day. And most of all, stay safe.